Welcome back to the Pratt Aycock Guide to the recent TREC contract form changes that become mandatory January 2016. We're now going to pick up with the third-party financing addendum as we referenced earlier. All of the information that was included in the contract that had to do with third-party financing has been migrated into this addendum. That's for clarity purposes. You'll find here there's a couple of things that were really modified in the third-party financing addendum that talk about the contract being subject to buyer approval or not subject to buyer approval. You can think of this section as referring to what used to be called credit approval. This is, can the buyer qualify for a loan to purchase the property? If it is required, there will be a number of days that are placed here in order for the buyer to qualify for that mortgage. If they do not qualify within that time period, they're able to terminate the contract, receive their earnest money back based on this particular section here. If you check this box, you do not have that luxury. This is something that did not change but was moved into this section, the property approval. Remember, guys, if the property does not approve for the loan, meaning you can't get insurance on it or the appraisal comes back too low, this section is not tied to the time constraint from here. This is completely separate. It could happen the day of closing. If the property does not approve, then the deal is over and the buyer gets their earnest money back. The other big adjustment to the contract is down here. This is the authorization to release information. One of the big changes that happened with TRED was they made it to where people could not share information with not only the real estate agents but the other party in order to facilitate the transaction. This is the non-public information, or NPI. That information can now be shared in order to facilitate the transaction simply by this authorization in this section. Could you imagine without this section, there would not be any way we could communicate as a title company with all the parties about all the facts going on with the deal. That is a great way to have a deal fall apart. Now, with this particular section, we're allowed to communicate with everyone and ensure that we can get the deal closed. Now we move to the unimproved property contract. This is the deal. This is the contract you use on a deal where there's no improvements on the property. It's just vacant land. When you use this contract, there's only really two things that are changing, or two things we want to point out that are not already discussed in the 1 to 4 family contract. So make sure you understand that a lot of the stuff in the 1 to 4 family contract definitely translates over into the unimproved property contract. One thing that you obviously will not find in this is in section 7. There's not going to be a hydrostatic testing provision. They originally had it in there, but it was more of an oversight. That should not be in there because obviously there's not going to be an improved property. There's not going to be a house or anything on it, so there's no need to worry with whether or not electrostatic testing would be done because it just simply would not. Something a little bit more important goes to speak with the rollback taxes. This has always been a point of confusion for a lot of people whenever they're buying raw land, because a lot of times it'll have an agricultural exemption, and you can have your property subject to rollback taxes. That's where the taxing authority can go back and charge for previous years as if the tax exemption was not in place. That can translate into a significant amount of money to a buyer. Within this section, they've clarified the fact that the seller is going to be liable if their change in use results in rollback taxes, not the buyer's change in use. Previously, we'd seen a lot of confusion where buyers felt like the seller should be liable even though it was the buyer's actions that triggered the rollback taxes. This section now greatly clarifies that it is actually the seller's liability only if their change in use is the result of the rollback taxes. So make sure to keep the cows on the property until the day of closing. That's essentially what this is doing, and this is what it is saying. The other three contracts that we'll actually touch on right now are the new home contract with incomplete construction or completed construction, as well as the farm and ranch contract. Pretty much everything we've touched on with the 1 to 4 family contract or this unimproved contract are going to be taken into consideration on these three forms. The big thing, obviously, to keep in mind is the rollback taxes prevention. That is going to be very important because the buyer is going to be liable for anything the buyer does after closing that changes the use of the land. But the seller's only going to be liable for their change in use in land while they own the property. That is a very important thing to remember because buyers may need to set aside additional money to cover tax increases that become into effect after closing. The next form is the seller financing addendum. There's not a tremendous amount of changes to this particular addendum. Mostly what you'll see is just changes in the way that things are worded to kind of match up with other parts of the contract. But one of the things that we do want to take the opportunity to highlight is in the event you are going to use seller financing on a transaction and the buyer is going to actually reside in the premises, you need to make sure that you speak with an attorney to help guide you through this process. With TREC, the SAFE Act, and all the other things that come into play when you're doing financing for an individual that plans to reside in the property, there are many things that can come up in terms of disclosures, processes that have not been in place for years. So this is fairly new things they're going to have to comply with, and we generally encourage the use of a registered mortgage loan officer to handle the application process as well as the qualification process on a seller financing note. Really only a couple of changes go into effect on the condominium resale certificate. Really what we're looking at here is now they're required to provide a balance sheet for the association. A lot of times they provided that anyway, but this is really good because now you can see whether or not the association is solvent. If it's not solvent, one of the things you want to let your client know is that they could be looking at future increases in the HOA dues as a result of solvency issues because they need more money to support that particular community. The other section is where they have more of a breakdown of the association fees from the transfer of the unit, where you have a description who it's payable to and the amount. Sometimes you'll have more than one payee, so you may have a management company, the actual HOA itself, who knows. So this will detail that information so you know who you're paying what and for what purpose. This form is the notice of buyer's termination of contract. We at the firm generally oppose the use of this form because you'll notice it does not have a waiver of liability and it's only signed by the seller. When possible, it's a good idea to use the TAR Form 1904 or other similar document that actually waives the parties' rights to sue each other, you as the agent, me as the attorney or title company, as well as the lender. We like the one that has the waiver of liability and agreement not to sue because it has a finality to it. However, if you do want to use this termination of contract, we try to have people limit it to just this first provision here, which is related to the option period. Keep in mind, it's at the title company's election to determine whether or not they will accept a buyer's termination of contract, and often we find that the title companies will want to have a mutual termination of contract, such as the TAR Form 1904. That way it waives the liability of all the parties upon release of the earnest money. Finally, we have the amendment form. This form had very little change to it. Of course, if you do have an amendment that extends the option period, it brings over the 5 p.m. deadline, which again is supposed to avoid the late nights. Always remember that if you do not put a dollar amount right here for the additional option fee, and if you do not deliver that option fee, you do not have an option. You do not have an option extension. You have to have some form of consideration. It can be $1, it doesn't matter, but you actually have to have it there, and it actually has to be delivered.